A Supreme Court decision just came down 8-1 that could strip millions of retired Americans of rights they thought they had. And if you or someone you love is retired, or getting close to retirement, or living with a disability, you need to understand what just happened, because this ruling doesn't just affect one firefighter in Florida, it affects every retiree in America who might face discrimination from a former employer over their retirement benefits, their health insurance, or their pension. And most people have no idea this case even existed. Before we dive in, hit that subscribe button right now, because decisions like this come down constantly, and they directly affect your money, your health coverage, and your legal rights. I don't want you finding out about these changes the hard way. Here's what just went down. On June 20th, 2025, the Supreme Court issued its decision in Stanley v. City of Sanford, Florida. The vote was 8-1. Justice Neil Gorsuch wrote the majority opinion. Justice Ketanji Brown Jackson was the lone dissenter. The court held that the Americans with Disabilities Act, the ADA, does not protect retirees who no longer hold or seek a job. In plain English, that means if you've already retired and your former employer discriminates against you when it comes to your retirement benefits, your health insurance, or other post-employment benefits, you cannot sue them under the ADA. The law that millions of Americans with disabilities have relied on for 35 years does not cover you once you've stopped working. Let me explain why this matters so much. The ADA was signed into law in 1990 by President George H.W. Bush. It was one of the most sweeping civil rights laws in American history. It banned discrimination against people with disabilities in employment, public accommodations, transportation, and government services. For people with serious medical conditions like Parkinson's disease, cancer, multiple sclerosis, or any of hundreds of other conditions that can force someone to retire early, the ADA was supposed to be a safety net, a guarantee that their former employer couldn't treat them worse than other retirees just because they had a disability. The Stanley decision just blew a massive hole in that safety net, and it happened 8-1. This wasn't a close call in the Supreme Court's eyes. Let me tell you the story of Karen Stanley because her situation could be yours or someone you love. If you're finding this helpful, make sure you subscribe right now. Because in my next video, I'm going to break down the 5 things every retiree must do before the end of the year to protect their retirement benefits. You don't want to miss it. Now, let's talk about Karen Stanley. Karen Stanley started working as a firefighter for the city of Sanford, Florida in 1999. Think about that job, a woman firefighter. She dedicated herself to protecting her community. She worked hard. She served with distinction. And when she started that job in 1999, the city of Sanford made her a promise. Every employee's handbook was clear. If you retired due to disability before you hit 25 years of service, you would receive free health insurance coverage until age 65. That was the deal. That was the promise the city made to recruit people like Karen and keep them serving. For almost 4 years, that was the deal. Then in 2003, the city changed the rules. They revised their benefits policy. Now, only employees with 25 years of service would receive health coverage until age 65. Disability retirees who left before hitting that 25-year mark would only get 24 months of health coverage after retirement. 2 years. Then you're on your own. Karen was already working there when the rule changed. She kept working. She didn't give up. She continued serving Sanford as a firefighter. Then in 2016, she was diagnosed with Parkinson's disease. Parkinson's is a devastating neurological condition. It causes tremors, stiffness, balance problems, and eventually makes it impossible to do physical work. For a firefighter, whose job requires physical fitness and quick reactions, a Parkinson's diagnosis is a career ender. In 2018, Karen was forced to take disability retirement. She had 19 years of service, not 25. So under the 2003 rule change, she only got 24 months of health insurance. After that, she was left without coverage. She was in her mid-40s, living with Parkinson's disease, and suddenly facing the loss of her health insurance. Let me put that in human terms. Parkinson's disease requires ongoing medical care, neurologist visits, medications, physical therapy, occupational therapy. The costs are enormous. Parkinson's medications alone can cost thousands of dollars per month. Without health insurance, those costs fall entirely on the patient. Karen Stanley was facing that financial cliff because her former employer changed the rules after she was hired. And in her view, they changed the rules in a way that specifically hurt disability retirees while protecting those who worked longer. Karen Stanley sued under the ADA. She argued that the city of Sanford's revised benefits policy discriminated against disability retirees. The city paid health insurance until 65 for those who served 25 years. But it cut off health insurance after 24 months for disability retirees who served fewer years. She said that distinction penalized people specifically because of their disability. The lower courts sided with the city. They said Karen no longer met the definition of a qualified individual under the ADA because she was no longer working or seeking to work. She appealed all the way to the Supreme Court, and on June 20th, 2025, the Supreme Court agreed with the lower courts, 8-1. 8. Quick legal note. This is educational information, not legal advice. Every situation is different. If you're facing discrimination as a retiree, consult with an employment attorney who specializes in disability law and retirement benefits. Now let me explain the legal reasoning. This is important because it determines who is and isn't protected going forward. The ADA in Title I, the employment section, says it's unlawful for an employer to discriminate against a qualified individual on the basis of disability. That covers compensation and retirement benefits. But here's the key phrase. A qualified individual is defined as an individual who can perform the essential functions of the employment position that such individual holds or desires. Justice Gorsuch's majority opinion focused on the words holds or desires. Those are present tense verbs. Holds means you currently have the job. Desires means you want the job right now. Gorsuch and 7 other justices said that because Karen Stanley was already retired, she wasn't holding a job or desiring one. She couldn't perform the essential functions of her firefighter position because she was no longer a firefighter. Therefore, she wasn't a qualified individual under the ADA. And if she's not a qualified individual, she can't sue under the ADA. End of case. The decision resolved what's called a circuit split. Different federal appeals courts around the country had been reaching different conclusions on this question. Some courts said retirees can still sue under the ADA for discrimination related to their retirement benefits. Others said no. The Supreme Court's 8-1 decision settles the question nationwide. Retirees cannot sue under the ADA for post-employment discrimination. Now let me explain the one dissenter. Justice Ketanji Brown Jackson wrote the sole dissent. Her argument is important for understanding what's at stake. Jackson said the majority's interpretation is too narrow. The ADA is a remedial statute, meaning it was designed to fix a problem. The problem was discrimination against people with disabilities. Jackson argued that Congress clearly intended the ADA to protect people with disabilities from all forms of employer discrimination, including discrimination in how former employees are treated after they retire. Jackson pointed out something important. Under Title VII of the Civil Rights Act, which prohibits discrimination based on race, sex, religion, and national origin, retirees can sue for discrimination in retirement benefits. Courts have interpreted Title VII broadly to cover former employees. Jackson said the ADA should be interpreted the same way. Congress modeled the ADA's enforcement provisions on Title VII. Congress said it wanted ADA protections to be identical to Title VII protections. But now, if 2 retirees face discrimination from their former employer, one being discriminated against because of their race and one because of their disability, they face different outcomes. The one discriminated against because of race can sue under Title VII. The one discriminated against because of disability cannot sue under the ADA. That asymmetry, Jackson argued, makes no sense given what Congress intended. But 8 justices disagreed. Hey, 73% of people watching right now are not subscribed. If you care about protecting your rights in retirement, join the community of seniors and retirees who stay informed about decisions like this one. Click that subscribe button right now. Now let me address something crucial. Even with this ruling, retirees still have some protections. It's not all bad news. Here's what you need to know about the protections that still exist. First, the ADA still protects you while you're employed. Any discrimination that occurred before you retired can still be challenged. If your employer changed your benefits specifically to force out disabled employees, and that happened while you were still employed, you may have a claim for what happened during your employment. The Stanley decision is specifically about discrimination that occurs entirely after you've already retired. Second, Title VII of the Civil Rights Act still covers retirees. If you're discriminated against in retirement benefits based on your race, sex, religion, or national origin, you can still sue. The Supreme Court has interpreted Title VII to cover former employees. Third, the Age Discrimination in Employment Act, the ADEA, protects workers 40 and older from age discrimination. Courts have interpreted the ADEA to cover some post-employment discrimination. If your retirement benefits are cut specifically because of your age, you may have an ADEA claim. Fourth, your state may have stronger protections. Many states have their own disability discrimination laws that go further than the federal ADA. Some state laws explicitly protect retirees in ways the federal law does not. California, New York, Massachusetts, and several other states have particularly strong disability discrimination protections. Check your state's laws before assuming you have no recourse. Fifth, ERISA may protect you. The Employee Retirement Income Security Act governs how employers must administer retirement plans and benefits. If your employer changed your retirement benefits in violation of the plan documents or in breach of fiduciary duty, you may have an ERISA claim that's separate from ADA protections. Sixth, contract claims may be available. If your employer made specific promises in writing about your retirement benefits and then broke those promises, you might have a breach of contract claim. Karen Stanley's situation is an example of this. When she was hired, the city promised health coverage until 65 for disability retirees. They later changed that. A contract or promissory estoppel theory might have been available even if the ADA claim failed. Now let me talk about the practical implications of this decision for the millions of Americans approaching retirement or already retired. This decision matters for three major groups of people. Group 1 is people who retired early due to disability. If you developed a serious illness or injury that forced you to stop working before you planned to, this decision means your former employer has more freedom to treat you differently than other retirees. They can reduce your health benefits, they can change your pension formula, they can alter your retirement package, and as long as they do it after you've already retired, you can't challenge it under the ADA. Group 2 is people with disabilities who are still working but approaching retirement. You need to pay close attention to your retirement benefits right now while you're still employed. If you suspect your employer may change your retirement benefits in a way that will hurt you once you're gone, you need to document that now and consider your legal options now, before you retire. Because once you retire, the ADA door closes. Group 3 is family members and caregivers of retirees with disabilities. If your parent, spouse, sibling, or loved one is retired and faces discrimination in their retirement benefits, the ADA may not protect them. You need to help them explore other legal options. Connect them with an employment attorney. Look at state law protections. Look at ERISA claims. Don't assume they have no recourse, but understand that the federal ADA path is now closed for them. Now I want to address some of the bigger picture issues this decision raises, because the Stanley case isn't just about one firefighter and one city. It's about a fundamental question. What protections do retirees with disabilities have in America? And the answer the Supreme Court just gave us is less than most people thought. Let's talk about what this means for healthcare and retirement. One of the biggest fears for people with disabilities who retire is losing health insurance. If you retire before 65, you're not yet eligible for Medicare. The years between early retirement and Medicare eligibility can be brutal. You're dealing with a serious medical condition that requires ongoing treatment. The costs can be devastating. Before the Stanley decision, people thought the ADA might protect them if their former employer cut their pre-Medicare health coverage. Now we know it doesn't. If you retire early due to disability, your health insurance protection from your former employer depends entirely on what your employment contract says, what your state laws say, and what ERISA requires. The federal ADA protection is gone. This is particularly critical right now because healthcare costs continue to rise. The average American with Parkinson's disease, which is Karen Stanley's condition, spends more than $2,000 per month on medications and treatment. Multiple sclerosis, which forces many workers into early disability retirement, can cost even more. Cancer treatment costs can reach tens of thousands per month. Without employer health coverage and before Medicare kicks in at 65, a retiree with one of these conditions faces a genuine financial catastrophe. Medicaid is an option for low-income individuals, but many middle-class retirees don't qualify. COBRA coverage allows you to stay on your former employer's health plan temporarily, but it's expensive because you pay both your share and the employer's share. A CA marketplace plans are an option but can be costly depending on your income and state. The point is that losing employer health coverage as a disabled retiree is a serious financial crisis. And the Stanley decision means the ADA won't protect you if your former employer tries to take that coverage away. Let me also address what this decision means for the broader disability rights landscape. The ADA was one of the crowning achievements of disability rights advocacy. It said, regardless of your disability, you have equal rights in employment. You can't be fired because of your disability. You can't be denied a promotion. Your employer has to make reasonable accommodations for you. Those protections remain intact for people who are employed. But the Stanley decision creates a two-tier system. If you're a disabled person who can keep working, you have robust ADA protections. If your disability forces you to stop working, your ADA protections in the employment context essentially disappear. That means the people with the most serious, most disabling conditions, the ones who literally cannot work because of their disability, have the least protection. That is the inverse of what disability rights advocates fought for. Disability rights organizations have already spoken out against this decision. The ARC, a national organization supporting people with intellectual and developmental disabilities, called it a setback. They said the decision narrows the reach of one of the most important civil rights laws for people with disabilities. But they also pledged to continue fighting for comprehensive protections for retirees with disabilities. Advocacy groups are calling on Congress to fix this problem legislatively. Congress could amend the ADA to explicitly protect retirees. It could write language similar to Title VII's treatment of former employees into the ADA. Whether Congress will act is uncertain. The political dynamics are complicated. But disability rights advocates are not giving up. They're pushing for a legislative fix. And if you're affected by this decision, you should contact your congressional representatives and urge them to close this gap. Now let me talk about steps you can take right now to protect yourself. These are practical action items regardless of where you are in the retirement process. First, review your retirement benefits documents immediately. Pull out your employee handbook, your retirement plan documents, and any letters or communications from your employer about your retirement benefits. Read them carefully. Look for promises about health insurance, pension payments, and other benefits. If your employer is changing those benefits after you retire, that's when you need legal help. Second, if you're still employed and have a disability, document everything. Keep records of communications with your HR department about retirement benefits. Keep records of your performance reviews. Keep records of any conversations about your disability and your retirement timing. If your employer is pushing you out or changing your benefits in ways that hurt disabled employees specifically, you want evidence of that discrimination while you're still employed, because the ADA still protects you while you're employed. Third, consult an attorney before you retire if you can. If you're a disabled employee approaching retirement, a consultation with an employment attorney before you finalize your retirement can be invaluable. The attorney can advise you about what rights you have while employed, what you might want to negotiate before leaving, and what to document. Once you retire, your options narrow. Get advice before you reach that point. Fourth, check your state's disability discrimination laws. As I mentioned earlier, many states have laws that provide broader protections than the federal ADA. A disability rights attorney in your state can tell you whether your state law protects you in ways the federal law does not. Fifth, look into ERISA protections for your retirement plan. If your employer is an ERISA-covered plan, there are federal rules about how they can modify benefits. Consult an ERISA attorney if you believe your benefits are being improperly changed. Sixth, consider your healthcare options before retiring. If you're planning an early disability retirement, map out your healthcare coverage carefully before you leave your job. Understand exactly what coverage you'll have, for how long, and what it will cost. Plan for the gap between your employer coverage and Medicare. COBRA, ACA, marketplace plans, and spousal coverage are all options to explore. Let me also address something that often comes up in these situations. What if your employer knew you were going to develop a disability and change the benefits while you were still working to preemptively cut your retirement benefits? This is what the Stanley dissent was concerned about. Justice Jackson pointed out that under the majority's ruling, an employer could specifically change retirement benefit rules to hurt disabled retirees while those employees are still working, and then argue that any discrimination happened post-employment and isn't covered. The majority tried to address this by saying that if discrimination occurred while the person was still employed, even if the effects are felt after retirement, the ADA might still apply. But this creates a complex factual question that will require future litigation to work out. If you believe your former employer made changes specifically designed to harm disabled retirees, an attorney needs to look at exactly when those changes were made relative to your employment status. Now let me connect this decision to the broader context of elder care rights in America. The Stanley decision is part of a larger pattern of legal developments affecting seniors and retirees. Let's talk about some of those other issues. Medicare and Medicaid are always in the crosshairs of budget debates. The programs that millions of seniors depend on for health care are constantly subject to proposed cuts and restructuring. Understanding how federal law protects your Medicare and Medicaid rights is essential for every senior. Nursing home rights are another critical area. The Nursing Home Reform Act gives residents certain rights, including the right to participate in their own care decisions, the right to be free from abuse and neglect, and the right to appeal transfers and discharges. These protections don't depend on the ADA. They're separate federal law. If you or a loved one is in a nursing home, know those rights. The Elder Justice Act addresses elder abuse and exploitation. It's a federal law that funds programs to prevent and respond to elder abuse, neglect, and exploitation. Whether this law is adequately funded and enforced is an ongoing policy debate. The Older Americans Act provides funding for nutrition programs, caregiver support, transportation, legal assistance, and other services for seniors. Programs under this act include Meals on Wheels and your local area agency on aging. These programs don't depend on the ADA either. They're a separate legal framework protecting seniors. I mention all of these because in the wake of the Stanley decision, it's important to understand that elder rights don't rise and fall entirely on the ADA. There's a complex web of federal and state laws protecting seniors. The ADA was one important thread in that web. The Supreme Court just weakened that thread for retirees. But the other threads are still there, and understanding all of them is essential for protecting yourself and your loved ones. Let me come back to the core question. What does the Stanley decision mean practically for millions of retired Americans right now? Here's the bottom line. If you're retired and living with a disability, you need to understand that the ADA's protections for you in the employment context have been significantly limited by this 8-1 Supreme Court decision. Your former employer has more legal freedom to treat you differently than it did before. That doesn't mean they can do anything they want. State laws, ERISA, Title VII for certain types of discrimination, and contract law still apply. But the federal ADA protection is gone. If you're approaching retirement with a disability, this decision makes it more important than ever to get your retirement benefits locked in and documented before you leave. Negotiate. Get promises in writing. Understand exactly what you'll receive. And consult an attorney before you finalize your retirement plans. And if you're currently employed with a disability and think you might be forced into early disability retirement at some point, start planning now. Understand your rights while you're still employed. Document any discrimination. Talk to an attorney. The good news is that disability rights organizations are not accepting this decision as the final word. They're fighting for a legislative fix. They're pushing Congress to amend the ADA to explicitly protect retirees. They're pursuing state law remedies. They're supporting litigation on ERISA and state law theories that don't rely on the federal ADA. The fight for equal treatment of people with disabilities in retirement is not over. It just got harder. One more thing I want you to understand about this decision. It is not partisan in the way you might expect. The 8-1 ruling included both conservative and liberal justices in the majority. Justice Gorsuch, a conservative, wrote the majority opinion. But Justice Sotomayor, a liberal, concurred in part, agreeing with the judgment even while expressing some concerns about the reasoning. Justice Thomas and Justice Barrett wrote a separate concurrence. The only full dissenter was Justice Jackson. This wasn't a partisan decision. It was a textual decision. 8 justices looked at the specific words of the ADA and concluded they don't cover retirees who no longer work. Justice Jackson read those words differently and would have ruled for Stanley. Legal interpretation is genuinely hard. Reasonable people can and do disagree. But the result is what it is, and the result hurts retirees with disabilities. So what should you do with this information today? Here are my final action steps. 1. If you are retired and living with a disability, consult an employment attorney about your specific situation and what state law remedies might be available to you. 2. If you are approaching retirement with a disability, get legal advice before you retire. Understand your benefits, get promises in writing, and know your rights while you're still employed. 3. Contact your congressional representatives. Tell them the Stanley decision left millions of disabled retirees without adequate legal protection. Urge them to amend the ADA to explicitly cover retirees. 4. Connect with disability rights organizations like the ARC, the National Organization on Disability, AARP, and others that are fighting for stronger protections. 5. Share this information with anyone you know who is retired or approaching retirement with a health condition. The people most affected by this decision often don't know it happened. 6. Check your state's disability discrimination laws. Your state may offer protections the federal law does not. And 7. Make sure your financial and healthcare planning accounts for reduced legal protections in retirement. You may have less recourse than you thought if your employer changes your retirement benefits after you leave. This is one of the most important Supreme Court decisions affecting seniors in years, and it came down 8-1. That should tell you something about how the law currently stands. It doesn't mean the law is right. Justice Jackson made a powerful argument that it isn't, and advocacy groups are working hard to change it. But until Congress acts or the court revisits this issue, this is the law. Disabled retirees have significantly weaker protections under the federal ADA than anyone realized. And you need to plan accordingly. Subscribe now because next week I'm going over the 5 documents every senior and retiree must have to protect their rights and their benefits in 2026. These are things most people don't think about until it's too late. Hit that subscribe button now and make sure you're ahead of the curve. Remember, this is educational content only, not legal advice. For your specific situation, always consult a qualified attorney. Stay informed, stay protected, and take care of yourself and your loved ones.